It is not a profit. You are a father, you must take care of the children. That's the least you can do. Educational expenses, food. Is this lady is not working? She does not have the ability to work. Now she is at least ensured, Lord, with the help of a father and a brother, children have been given an education. Otherwise, the children would have been on the streets today.
The father of the lady comes with his official car with red light and 2 jeeps, police jeeps. No, please don't disturb me. I have the facts. Even now, would you direct me to pay the maintenance, my lord?
Yes.
Please read this. My lord, they didn't want the father and the children to be met. There was a campus selection. She was selected by international company. She was paid 1,50,000 as admitted by them. Now they want to send this girl to Florida, USA, and want me to pay 4,80,000 per month. Is it logical? Is it ethical? Is it legal, my lord? What it shows? It demonstrates, it depicts your arrogance, your egotism, your despotism. That's what you did for me. Otherwise, why would I leave you? I would have happily lived with you. And this, we would not have come to this position of sharing my income. This is not relevant, my lord. You filed dowry harassment case against my mother, my brother who died, and his wife and children I have to look after now. Now, apart from that, my lord, you went to domestic inquiry, domestic violence act, where you suppressed the matter that you have divorced me. If you had told the matter that you are divorced, Section 12 of the Domestic Violence Act is not applicable when minors cannot say anything. Now she is 24 years, my lord. Could she not have telephoned to me? Could she not have sent a message? Papa, I am going for Florida. I want your blessings. But still you want the 8 lakhs from me for marriage, which is contingent.
There is no dispute on the amounts at all. Not a single dispute raised, not with respect to the amount spent by us.
Marriage expenses at 8 lakhs each to the children.
8 lakhs to the children. 1,98,000 is for 1 year's school fee, 1 year's school fee, and 3,21,000 was arrears of maintenance. But the whole direction was that the court must consider what the maintenance amount is and make a determination. There's absolutely no consideration, and all the material, my lord, has been completely ignored.
We'll ask.
Very well.
Yes.
May it please you, Lord. My lord, your lordship may come to my writ petition.
No, before you proceed,
Yes.
High Court in which case has directed to pay 3,000? Where is the order?
Order is dated 18/10/2016, my lord.
18/10/2000.
18/10/2016.
Is it filed?
It is not filed here. In another criminal case, it was ordered. It was a considered order, and the other party was also present. 3,000 each was given to the child. It was 13 years ago. At that time, that 3,000 was very good amount. Now it may not be good amount, but I have paid up to the age of their attaining majority. I have paid up to date. 6,000 for 2 children. This is one aspect of the matter.
Then what about the school fees and other things?
School fees is, my lord, maintenance is not defined anywhere in any book. I have been making a research on this. Maintenance is not defined in any act, Family Court Act, Hindu Marriage Act, Maintenance Act, nothing. It is by the rule, by procedure, by precedents, by judge-made laws. We have come to understand that maintenance is food, tuition fees, medical fees, their transportation. Therefore, the second order passed by the learned trial court judge asking me to pay school fees is a part of maintenance.
No, before that.
Therefore, my submission is there cannot be a maintenance for transportation, maintenance for food, maintenance for fees. That's my submission. My submission is 3,000 plus 3,000 for 2 children,
No,
or
1 minute.
inclusive of all this.
In a criminal proceedings, that order is passed when? Which year?
18/10/2016.
18/10?
2016, 16.
This petition is filed?
This
No,
petition
that
is filed
not
in
that
13.
criminal proceedings is not something about a maintenance. No, when the petition is filed before the court, when the evidence is let in, court has to independently decide it, how much is the maintenance
Yes.
you're entitled.
Yes,
And after determining the maintenance,
yes, ma'am.
then this much of amount the father is already paying,
Yes,
deduct it, and then fix the maintenance.
yes.
But that is not done by the court.
No, my lord, it is not challenged. You are very much there for the past 10 years fighting the case in the court, and you did not challenge this 3,000. 3,000 was agreed, was ordered, and I paid 1,40,000 on that date I paid.
Unfortunately.
And there was no objection. You did not
Sorry.
file an application for modification.
No.
You did not file an application for 10 years.
Without an order copy being on record either before the court below
I'll produce.
or
all.
before this court.
Yes, ma'am.
Now we are talking about something of 6,000, and but unfortunately court below cannot say High Court has asked in granted 6,000, so I will also do.
My lord,
This is an application.
it's not like that.
Application.
It's not like that. I'm sorry, my lord. It's not like that. It was adjudicated. It was consented. Parties were present. It's not an ex parte order. We were present. And from 16 onwards till today, 2024, you have not raised your little finger saying that it is more or less. You should have applied for a modification, applied for enhancement. That is not there. That is what is called as acquiescence. You have accepted and have paid and you have accepted also. Therefore, you cannot now go back and say, at this after 10 years in 2024,
Have you
when the
seen
girls
the
are, when the girls are drawing 1,50,000 salary. No, please sit down. I did not
Sit down,
interrupt
sir.
you.
I will take instructions from the
No,
court.
please
not
sit
from you.
down. Please sit down.
tell me to
My
sit down.
lord, this you have raised when the two children have become majors 4 years ago, when the two children are earning 1,50,000 per month, and they don't have courtesy to tell me that they are doing this.
That date till 2024, my lord, these applications have been pending. And now it is considered saying simply on a statement made that 3,000 rupees was paid by me, and therefore that is the amount of maintenance, and therefore nothing more has to be paid. You must not look at any of this voluminous evidence that we have placed before the court, pointing out as to what is the exact expense. We are not asking for profit, my lord, here. It is not a profit. You are a father, you must take care of the children. That's the least you can do. Educational expenses, food. Is this lady is not working? She does not have the ability to work. Now she is at least ensured, my lord, with the help of a father and a brother, children have been given an education. Otherwise, the children would have been on the streets today. And today the father is saying, I'll pay 3,000 rupees, that is maintenance.
Yes, yes, my lord. In 2013, 14, 15, 3,000 was a good money for me. I am not a businessman. I am only a software engineer. Your lordship may kindly permit me to say a few background of this. My learned friend has not stated any background. My lord, she is the daughter of a High Court judge. He is the daughter of a tailor. Because he was a BE graduate, handsome, simple man, honest man, you married your daughter with him. And from day one till today, you are harassing me. A small instance, I may bring it at the request of this honorable court. There are many instances where I have been abused, humiliated, and thrown out. One small instance you may permit me to submit. When Mr. Mujib was here, a registrar of this honorable court, he arranged this marriage. And when there was difference of opinion between the husband and wife, he tried for a compromise. A compromise meeting was arranged in a mosque. Justice, the father of the lady, comes with his official car with red light and 2 jeeps, police jeeps. No, please, don't disturb me. I have the facts. After all,
Maintenance, sir, not about the father. I'm
which
sorry.
is based on the
You
facts.
can't keep making
I am
statements
taking
like this.
permission of this honorable
No,
court,
considering-
bring you to your kind
Considering
notice,
that
how he
dispute,
treated me,
this
how the wife also is responsible for this tragedy.
whatever it is, that would be considered in a case where on
She is a
on
BSc
matrimonial
graduate.
case- No,
She is
let's
healthy.
not
She
go
must
into
have
all those
taken
stuff.
an appointment and looked after her children also. And you have no, I would now your honor doesn't want to permit me to say that give this information or incident. I would request my lord to see page number 64 of my book. Would
Yes.
you even now would you direct me to pay the maintenance, my lord?
Yes.
Please read this. My lord, they didn't want the father and the children to be met. There are incidents which my learned will object and your lordship may also not permit me. I'll just read this, my lord. This is an application filed by the lady, the wife. What they say is, this honorable court may be pleased to pass an order prohibiting the opponent petitioner, me, husband, entering and visiting their children's and their any future schools, colleges, hostel of their future studies and visiting at their residence and from attempting to communicate in any forum whatsoever with these aggrieved children, minor irfan so including personal, oral, written, electronic or telegraphic contact
Yes.
in the interest of the protection and promotion of their welfare and healthy development and in the ends of justice. Fine words, but butters no parsnips. These are the words used by them. What is the law about this? I wanted to bring it to your lordship's kind concern. The law is, once the daughters do not want to engage themselves with the father, do not want to maintain relationship with them, they cannot claim the maintenance. I would submit 3 judgments to that.
Is it so? They
Now
never
they
had a
filed
contact
today,
with the
day after
father?
yesterday, day before yesterday.
There's a report of my lord, a councillor who was appointed in 2014 to ensure that the children meet the father. And I have stated the report in my objection statement as to what was said and what happened. And my lord, I must point out to you what happened. One night, the mother and the 2 children were thrown out into the streets by the father and his mother. And my lord, on the street, they were in the middle of the night. They were on the street, and thereafter, my lord, all of this problem happened. So to make allegations and in the petition, my lord, if your lordship see the kind of allegations made against his former father-in-law, he accused him of murder of his own son.
Where is the document? Where is the evidence? These are all right. This
Please see, my lord, if my learned friend
the
is
father of
saying-
the wife for every
No. I
application.
think we are expanding the scope of the petition itself.
Correct.
Please come to the judgments. Which one you're relying on?
No, my lord,
Because on some judgment.
now that he has submitted about the mediation, visitation rights,
Hmm.
they did not honor the orders of the honorable court.
Hmm.
They did not encourage me to meet my children
Hmm.
because children were brainwashed.
Yes.
The children were told that the father is a devil, father is a murderer. Therefore, the fact that I went to the director in the family court, requested him to appoint a mediator to supervise the visitation rights. I will just read a letter that mediator who was appointed to supervise the visitation rights has written a letter to the director. I have not.
That's what
produced
is
it.
extracted. That I.
No, this is a letter by mediator who was appointed to supervise the visiting rights. 2 minutes, one second. The respondent is not bringing the children for visitation as directed by the honorable court. Since last month also, on last Saturday of the month, 25/10/2014, I waited till 4:30 p.m., but they did not come. Today also, they have not come. Request you to acknowledge these absence so that I can produce some in the court. This is by the Deputy Director, Mediation Center. This is the report he has given. I have not produced it, but I have got a copy. I will produce it.
Yes.
So everywhere they have frustrated me. Everywhere they have blamed me. See, if that was the case, they inflicted on me this inferiority complex. I am the High Court judge's daughter. I can send you to jail. She went to the extent of beating my old 80-year-old mother. It was at that time I did not throw her. I took her in my car and left it in her house. I did not throw them. They are not small people to be thrown. They are all educated and influential. She could have simply called a cab and gone. This is a story they are making. If your lordship permits me, as your lordship said, if this writ petition does not enlarge the scope for adducing all the facts that I have transferred in the trial court, if only time is given, I will be able to convince
No.
what are the hardship I have gone through. She is also
let's look at the legal position.
No, I'll
and
come
then-
to
and
the
then
points, my
orders.
lord.
Yes.
Number one, first order. The petitioner is hereby directed to pay an amount of 1,98,397 to the respondent, which was school fees. This application was made before the trial court also. That order I have produced. Trial court said this is not permissible. There is no law in the Family Court Act to provide school fees because it is part of maintenance. So it came to be rejected. When this visitation rights was frustrated, for about 1 year, I came regularly to see my children. They did not talk to me. They were held back by the wife, by the mother. They are living with the mother. So therefore, logically, psychologically, they will be moved towards the mother. On that frustrated date, I filed a memo and said, I want to withdraw this GNWC. The fact that I have applied for GNWC, namely the fact that I wanted the custody of my children, shows my bona fides and falsifies their case. I apply for custody of the children. You did not. You went on proving the case for 12 years, 13 years, 14 years, accusing me. Even day before yesterday, you file an application and say that this lady, this first girl who is 24 years, she completed her BE in distinction. There was a campus selection. She was selected by international company. She was paid 1,50,000 as admitted by them. Now they want to send this girl to Florida, USA, and want me to pay 4,80,000 per month. Is it logical? Is it ethical? Is it legal, my lord? I may be pardoned to say this, my lord. They are trying for a ransom. She married another person who was 60 years retired, deputy commissioner of income tax. And she comes and tells the trial court, luckily I am married to a rich man. I am living in a big bungalow. My children are looked after by them. Is this how you come to the court and say? What it shows? It demonstrates, it depicts your arrogance, your egotism, your despotism. That's what you did for me. Otherwise, why would I leave you? I would have happily lived with you. And we would not have come to this position of sharing my income. I am getting 84,000, my lord, per month. I have my wife. I have married again. I have 2 children who are 10 years and 9 years old. They are admitted to the schools. And I have a widowed mother who is bound by wheelchair with all comorbidities. I have to look after them. When you filed 482 dowry harassment against me,
Now,
my brother died. That still is going on. You went to domestic violence.
We are in a maintenance matter. What is wrong with the order passed by the court below? Please tell the court. Only on the merits of the matter, because we do not
This is
have
not
that-
relevant, my lord. You filed dowry harassment case against my mother, my brother who died, and his wife and children I have to look after now. Now, apart from that, my lord, you went to domestic inquiry, domestic violence act, where you suppressed the matter that you have divorced me. If you had told the matter that you have divorced, section 12 of the domestic violence act is not applicable. When I went there and filed my wakalat and brought to the notice of the court that when once divorce is there, maintenance, domestic inquiry does not survey, therefore they dismiss. Dismissal order, they challenged it under section 49, 89. Went to the district judge and said, the word dismissal should not be there. It has become infructuous. Therefore, 4 years I had to drag on. This is the conduct of the persons. Now I will come to the order, my lord. First order is 1,98,000, which I submit with great respect, is not exclusive of the maintenance.
Next.
It is an integral part of the maintenance.
Yes.
Number 1. Number 2, petitioner also directed to pay 3,21,000, which I have paid arrears with great difficulty. I had paid 1,44,000 in that criminal proceedings where 6,000 was ordered by this honorable court.
Yes.
Later of this order, I told my client, this is arrears of rent. I have admitted it and I had acknowledged it.
Yes.
I paid 3,21,000, my lord. That I have no grievance, my lord. The third one is the my important submission. Third one is petitioner is also liable to pay 8 lakhs each to the children for their marriage expenses. This is my important submission. Nowhere there is maintenance order for the children. especially for major children. No act enunciates, emphasizes, or orders, makes an order. There is no law asking me to pay marriage expenses.
Yes.
Number one. Number two, for major children who is 24 years now, I do not know whether she will marry or not. It is only a hypothecated version of the trial court. We don't know. It's a contingent feeling. She may not marry, but still you want me to pay? That is not my ground before my Lord. My ground before my Lord is a major daughter, earning daughter, is not entitled for marriage expenses. To support, I have produced 3 judgments, given the copy. The first page itself says, my Lord, Supreme Court holds a major daughter not entitled to education expenses from father as she does not want to maintain relationship with him.
Yes.
My emphasis on this, my Lord.
Yes.
Even yesterday when I received this application by my learned friend, I called my client and showed it to him. He was only tears in his eyes and nothing else, no answer. Because she passes BE, she doesn't inform me. She wants to go to Florida, doesn't inform me. She is not a child. Minors, mother will represent, no doubt. Minors cannot say anything. Now she is 24 years, my Lord. Could she not have telephoned to me? Could she not have sent a message? Papa, I am going for Florida. I want your blessings. But still you want the 8 lakhs from me for marriage, which is contingent. I invite my Lordship's kind attention to
Kumar Rate.
first judgment.
Yes.
Page number 9.
Yes.
8, 9. My Lord.
Hmm.
Last but one para.
Hmm.
I have marked it, I think.
Yes.
In so far as the daughter's expenses for education and marriage are concerned, it appears from her approach that she doesn't want to maintain any relationship with the appellant and is about 20 years of age. She is entitled to choose her own path, but then cannot demand from the appellant the amount towards education. We thus hold that the daughter is not entitled to any amount, but while determining the amount to be paid as permanent alimony to the respondent, we are still taking care to see that if the respondent so desires to support the daughter, funds are available.
Yes.
My Lord, that is, in a case of permanent alimony for wife, that is what now my learned friend will bring in that famous case, Rajeev case.
Yes.
She is a part of alimony includes marriage expenses. That is alimony. That is a lump sum payment to the wife. Here wife is
Already divorced.
already
now.
having a...
Yes, next judgment at page 12.
Now
High Court
I'll
of
read.
Bombay.
This is the first judgment, my Lord.
Then High Court
Second
of Bombay.
judgment, I'll bring it to your Lordship's kind consideration. This is my notes. I'll just quote this, just for my Lord's kind consideration. There is no straitjacket formula for fixing quantum of maintenance. A careful and just balance must be drawn between all relevant factors. The maintenance awarded must be reasonable and realistic, and avoid either of the extremes. That is, maintenance awarded to the wife should neither be so extravagant which becomes oppressive and unbearable, like arrears of maintenance, school fees, marriage expenses for the husband.
No, without
Nor
a
should it
citation,
be-
Mr. Counsel, without a citation, just like that, you can't read the notes, sir.
Yes.
Those are all the settled law. Now, as far as on the merits of it, you have advanced your arguments. Court
Yes.
has noted down. Anything?
Yes, I have.
Yes.
May I just, in Islamic law, what the position is, that a father is liable to maintain the daughter till she marries. May I just pass on that judgment, my Lord? Para 9 and 10, my Lord, at page 239.
Yes.
And finally, my Lord, if your Lordship sees 10, I'll just read 10 because 9 is the extract of Muslim law. Thus, both under personal law and under statutory law. Para 10 at 240.
Yes.
Thus, both under personal law and the statutory law, the obligation of a Muslim father having sufficient means to maintain his minor children unable to maintain themselves till they attain majority, and in case of females, till they get married is absolute, notwithstanding the fact that the minor children are living with a divorced wife. That's one. And then, Lord, Your Lordship may kindly see the judgment in Rajnesh's case.
Check that.
As to what is this maintenance, my learned friend asked, saying there is no definition. Para 91 at page 375.
Yes.
Living expenses of the child would include expenses of food, clothing, residence, medical expenses, education of children. Extra coaching classes or other vocational training courses to complement the basic education must be factored in while awarding child support, albeit it should be a reasonable amount to be awarded for extracurricular coaching classes and not an overly extravagant amount which may be claimed. Education expenses of children must be normally borne by the father. If the wife is working and earning sufficiently, expenses may be shared proportionately between the parties.
Yes.
And in the previous paragraph, my lord, para 90.4, an able-bodied husband must be presumed to be capable of earning sufficient money to maintain his wife and children. Cannot contend that he is not in a position to earn sufficiently to maintain his family, as held by the Delhi High Court and so and so. Onus is on the husband to establish with necessary material that there are sufficient grounds to show he is unable to maintain the family and discharge his legal obligations for reasons beyond his control. If the husband does not disclose the exact amount of his income, an adverse inference may be drawn by the court. Court in so and so cited the judgment in so and so with approval and held that the obligation of the husband to provide maintenance stands on a higher pedestal than the wife. And from what date it should be awarded? It is from the date of the application. That is what Supreme Court has said. And Lord, he himself in his affidavit filed before the court, I'll just please see page 57 of the petition, Lord, what he has said.
Yes.
Of my petition, page 57. I'll just read two paragraphs more. He says, I am desirous of and capable of educating my daughters in any professional stream. And I'm desirous and capable of conducting and celebrating the marriages by meeting high-end expenses with any good and high-profile family. I don't know. Marriage need not be with any high-profile family. It has to be with a good man.
Yes, that is when you give me custody. That was the application for
These are
custody, wherein I have stated, I am ready to take care of them, give my education to the best of my ability. A tailor's son cannot send his daughter to Florida. He can send her to St. John's School or National High
Yes.
School.
Lord, I think, Lord, obligation of a father is to the children. Mother is not asking for, or the wife is not asking for money. I can understand all these allegations against the mother. But children are saying, I have to be educated. Mother has taken money from the father and the brother to educate. Now it is your obligation to pay. And the entire expenses which we have listed out, and which, my Lord, your Lordships will find, which we have pointed out in the petition from page 127 onwards, has not been disputed at all. Not a single question, even in cross-examination, challenging any of it.
Yes.
All of that, no, actual expenses incurred. We are not asking for anything more. Pay those expenses so the children are, at least the children have the money, and I repay my father and my brother. And all these arguments, Lord, that he is a judge or whatever he may be, he is also a grandfather. So he is undertaken that obligation of educating the children, ensuring that they come to this level, which the father has not. And on 2014 onwards, he's not even bothered to look at the children till now.
Yes.
Two important things I forgot to submit before your lordship.
Please, sir.
When a compromise meeting was held
Yes.
by a registrar of this honorable court, she demanded all the jewels that I have given to her, the jewels that they have given to me, and the gifts we got. If I am not mistaken, gifts were in plenty because a high court judge was celebrating his daughter's marriage. Everything she took it. She did not bother to give me a single gift packet. And here is the acknowledgement for having taken jewels worth 500 grams, which is now 30 lakhs. It's not as if I deny her this marriage expenses, she will be bereft of funds. She has funds. 30 lakhs is there available with her. This is her written.
Yes.
Then second important point that I forgot to mention with your honor's kind permission, with lordship's kind permission. Your lordship may kindly turn to page 76. This is the application IA number 10 for maintenance. Has he spoken about, claimed or prayed about the marriage expenses? No. Application 11 for school fees. Has he claimed about the marriage expenses? Is there a law? Was there a pleading? There is no law. There is no pleading. There is no prayer. Therefore, there is no adjudication. I was unable to answer that. If he had pleaded, this is most important in my respectful submission, my lord, that throughout the length and breadth of your case, there is not an iota of mention of marriage expenses demanding. It is a trial court's ambition, trial court's feeling that it should
Yes.
grant this matter. Yes, maintain it. The
Yes.